What if schools could keep parents from knowing critical information about their child? What if doctors could give dangerous advice to their patients? And what if the definition of who counts as an American citizen changes? These aren't hypothetical questions. They are real legal battles happening right now in courts and government across the country. That's what we are breaking down today on Wall on Law. Hello and welcome to the 9th episode of Wall on Law. My name is Jonas Wall, and I am a pre-law student at the University of Delaware. On this podcast, we cover what's happening across the country in law and policy and how it affects your daily life. Today, we are looking at 3 major legal developments coming out of the Supreme Court. First, we'll break down a Supreme Court case out of California where the court temporarily blocked policies involving transgender students and parental notification. Then, we'll turn to a major First Amendment ruling out of Colorado where the Supreme Court sided with a therapist challenging a ban on conversion therapy. And finally, we'll look at a Supreme Court case being argued right now that could redefine birthright citizenship and ultimately who counts as an American. First, let's start with the California Supreme Court case. On Monday, March 2nd, the U.S. Supreme Court ruled 6-3 to temporarily block a set of California policies that limited when schools could share information with parents about the gender of transgender public school students. Let's break this down. Currently, there are policies in California schools that protect student privacy and prevent discrimination by restricting schools from disclosing certain information about a student without their permission. Several parents and advocacy groups challenged these policies, arguing that they went against the parents' constitutional rights. One of these rights under pressure is the First Amendment, because some parents say that being kept in the dark about their child's gender conflicts with their religious beliefs about gender and family. Another right under pressure is the 14th Amendment, which courts have interpreted to give parents a fundamental right to make decisions about their child's upbringing. On the other hand, supporters of these policies state that forcing schools to automatically notify parents about a student's gender could expose some students to unsafe home environments. Therefore, they are saying that schools sometimes need discretion to protect students who may not yet feel safe sharing that information at home. So just in case algebra was not stressful enough, let's now throw in constitutional rights. This case was first brought before a federal district judge who initially agreed with the supporters and blocked the policies. However, a federal appeals court later paused that ruling, which temporarily allowed the policies to remain in effect while the case continued. The Supreme Court has now stepped in through an emergency order, reinstating the district court's decision and blocking the policies that protected student privacy while the lawsuit continues through the courts. It's important to note that the Supreme Court did not issue a final ruling on whether the policies are constitutional. Instead, the court issued what's known as an emergency order, sometimes called the court's shadow docket, where they decide what rules should apply while the case continues to move through the legal system. In doing so, the majority indicated that the parental advocacy groups had raised serious concerns under the First Amendment and the 14th Amendment. The lawsuit is still moving through the lower courts, so we do not have a final ruling, and it could return to the Supreme Court for a full decision on these policies. And that brings us to why this matters to you. Because at its core, this case isn't just about one policy in California. It's about 3 competing interests: the rights of parents, the authority of schools, and the privacy of students. Public schools make decisions every day about what information they share with families and what information they keep confidential. And depending on how courts ultimately rule, the outcome could influence school policies nationwide, determining whether schools must notify parents about gender issues, how much privacy students have in educational settings, and how constitutional protections, like religious freedom and parental rights, are defined in modern school environments. In other words, while this ruling is temporary, the legal questions behind it could shape education policy and law debates for years to come. Now, I want to cover another major Supreme Court ruling, again affecting the LGBTQ+ community. On Tuesday, March 31st, the Supreme Court ruled 8-1 in a case involving a Colorado law that banned licensed therapists from engaging in conversion therapy with minors. Let's break this down. Conversion therapy is a set of practices that attempt to change a person's sexual orientation, often through counseling or other interventions. Back in 2019, Colorado passed a law banning licensed clinicians from trying to change a minor's sexual orientation. This includes attempts to reduce or eliminate same-sex attraction. Violations could result in fines of up to $5,000, and over 20 other states have passed similar laws. This law was challenged by a licensed counselor, Kaylee Childs, who argued that the ban went against her First Amendment right to free speech, specifically her ability to have conversations with clients based on her religious beliefs. The Supreme Court overwhelmingly agreed with her. Speaking for the majority, Justice Neil Gorsuch said the law didn't just regulate medical treatment. It targeted speech, and more importantly, speech based on someone's viewpoints, which is one of the most heavily protected forms under the First Amendment. Now, importantly, the court did not say that conversion therapy is safe or effective. Instead, the ruling is about who gets to control what can be said in a therapeutic setting. Justice Jackson dissented, arguing that states should still be able to regulate licensed professionals, especially when it comes to protecting patients from harmful treatments. But because she was in the minority, her view does not control the outcome of the case. So what actually happens next? The Supreme Court did not fully strike down the law. Instead, it sent the case back to lower courts and told them to apply strict scrutiny, the highest level of review. And in reality, laws almost never survive strict scrutiny. So while the law is not officially gone, this ruling makes it likely that Colorado's ban and other laws that are similar to this one across the country will eventually be struck down. This is also different from the California case we talked about earlier in the episode. That case involved an emergency order where the court temporarily stepped in. Here, the court issued a full ruling after hearing arguments, meaning it directly addressed the First Amendment issue. Now, zooming out, what changes because of this ruling? This ruling could open the door for similar laws in other states to be challenged and overturned, potentially making conversion therapy more widespread. Additionally, and this is where things get really important, Justice Jackson warned in her dissent that this ruling opens up a can of worms. What she meant is that this logic could be expanded beyond this case. For example, a licensed therapist might now claim a First Amendment right to advise a vulnerable patient, like a depressed teenager, to reject medical treatment and instead rely on unproven alternatives, simply by framing that advice as protected speech. On the other hand, some advocacy groups argue this ruling could cut both ways. If the First Amendment protects some forms of therapy, it could also be used to defend providers offering gender-affirming or reproductive healthcare in states trying to ban it. So ultimately, this ruling is not just about conversion therapy. It raises a much bigger question. How far does free speech go when it intersects with medical care? And the answer to that question could reshape not just LGBTQ+ rights, but the entire healthcare system moving forward. Finally, let's cover a case currently being argued at the Supreme Court involving birthright citizenship. First, it's important to understand what's at stake. On January 20th, 2025, President Donald Trump signed an executive order attempting to end birthright citizenship, the long-standing rule that anyone born in the United States is automatically a U.S. citizen. His order would include children of immigrants who are in the country illegally, as well as those here legally but temporarily, like students or workers on visas. Now, this issue goes all the way back to 1868. The 14th Amendment states that anyone born in the United States and subject to the jurisdiction thereof is a citizen. Originally, this was meant to overturn rulings like Dred Scott and ensure that formerly enslaved people and their children were recognized as citizens. But over time, that clause has been interpreted much more broadly to apply to almost everyone born on U.S. soil. Because of that interpretation, every federal court that has reviewed Trump's order so far has blocked it, with at least one judge calling it blatantly unconstitutional. Now, the issue has reached the Supreme Court. So what is the Trump administration arguing? They are arguing that the 14th Amendment was never meant to apply this broadly. Instead, he argues it was intended for only formerly enslaved people and their descendants, and that extending it to children of temporary visitors, like illegal immigrants, goes too far. There were also concerns that were raised about birth tourism, where individuals travel to the U.S. to give birth so their child gains citizenship, arguing that this creates citizens with no real connection to the country. On the other side, challengers argue that the 14th Amendment creates a clear rule. If you are born in the United States, you are a citizen. They say this rule is simple and prevents the government from randomly deciding who qualifies. It's also important to look at precedent, especially the 1898 Supreme Court case, United States v. Wong Kim Ark. This case affirmed that children born in the U.S. to non-citizen parents are still citizens. For over a century, that decision has been the foundation of how birthright citizenship is understood in the United States. So basically, this new case brought by the Trump administration is asking whether the court is willing to reinterpret a precedent that has shaped what it means to be an American citizen for more than 100 years. As of now, the Supreme Court has not issued a ruling, but one is expected by late June or early July. So why does this matter? If the court sides with the administration, the impact could be massive. Some estimates suggest that up to 250,000 babies born each year could be affected, and families may be forced to prove their child's citizenship status. This burden of proof could create an entirely new layer of legal problems at birth. And while the order is technically forward-looking, critics warn that the legal reasoning behind it could go much farther. If the court reinterprets the 14th Amendment, it could open the door to challenges against people who have already been recognized as citizens, raising questions about legal status and even access to basic rights, like voting and education. So while we are still waiting on a final ruling, one thing is clear. This case isn't just about immigration. It's about the meaning of citizenship itself in the United States. One more interesting note, this case is also historic for another reason. President Trump actually attended oral arguments at the Supreme Court, becoming the first sitting president ever to sit in on a case in person. For context, this is something that even most lawyers don't get to do, so he skipped a few steps there. And with that, we are now at the big picture. Across all three of these cases, California, Colorado, and now birthright citizenship, one underlying question is being asked. Who gets to define rights in America? In the California case, it's about the balance between parents, schools, and students, and who controls information in education. In the Colorado case, it's about the conflict between free speech and government regulation, especially when it comes to medical care and professional standards. And in this birthright citizenship case, it goes even deeper. It's about who qualifies as an American. Depending on how the court ultimately rules, rulings in these cases won't just resolve individual disputes. They could reshape how we understand constitutional rights for years to come. In other words, these aren't isolated cases. They are part of a much bigger shift in how the Constitution is being applied in the modern era. Before we close out, thank you for listening to the 9th episode of Wall on Law. If this episode helped make the law feel a little more understandable, that's the goal of this podcast. Make sure to follow or subscribe to Wall on Law so you don't miss future episodes. And you can also sign up for our email list at wallonlaw.com to get notified whenever a new episode drops. Thank you again for listening, and I'll see you next time on Wall on Law.